So hello, everybody. Welcome. Thank you for joining our panel, 2020 Vision, Trends and Challenges in the Enforcement of International Arbitral Awards. We have a really terrific lineup of speakers to take a look today at some of the key issues in the area of enforcement, where we stand and where we're headed. So before we start, just one order of business. I'm going to put up a slide for CLE credit. There we go. The code for CLE credit is 598238. The CLE affirmation form is available on the conference landing page. To obtain CLE credit, you need to write down the code and enter it into that form, and then submit the completed form to ILW@ila-americanbranch.org by November 6th. The code will not be provided after the panel, but I'll show it again towards the end of the presentation for any latecomers. So in the interest of time, I'm going to give a very short introduction for each of our very esteemed panelists, and then we can dive right in. So we'll aim to leave time for questions at the end. Please feel free to send them in using either the chat function or the Q&A function at the bottom of the screen. So first, Andrea Bjorklund is Associate Dean, Professor, and the E. Fortier Chair in International Arbitration and International Commercial Law at McGill University Faculty of Law. She is an advisor to the American Law Institute's project on restating the US law of international commercial arbitration, as well as a member of the advisory board of the Investment Treaty Forum of the British Institute for International and Comparative Law. She is an active arbitrator and expert on both commercial and investment arbitration matters, and was previously attorney advisor on the NAFTA arbitration team in the Office of the Legal Advisor of the US Department of State. Then we have Lee Caplan is a partner at Arent, where his practice focuses on international arbitration, international investment law and policy, and public international law. Lee also previously worked at the US Department of State's Office of the Legal Advisor, where he defended the US in international arbitrations and participated in US investment treaty negotiations. Lee serves as a member of the US delegation to UNCITRAL. He's co-author of a leading commentary on international arbitration and an adjunct professor at the Georgetown University Law Center, where he teaches a course on international courts and tribunals. Dr. Kabir Duggal is a senior international arbitration advisor in Arnold and Porter's New York office, focusing on international arbitration and public international law matters, serving as both counsel and arbitrator. Dr. Duggal is a lecturer in law at Columbia Law School, teaching international investment law and arbitration, and also acts as consultant for the United Nations Office of the High Representative for Least Developed Countries on Investment Matters. And then Alyssa King is an assistant professor at Queen's University Faculty of Law in Kingston, Ontario, where she teaches contracts and civil procedure. Professor King's research focuses on arbitration and comparative civil procedure. So as you can hear, we have a very distinguished and great group of panelists, and we're very much looking forward to hearing all of their thoughts on the topic today. So let's dive right in. So when we talk about enforcement, we're talking about an international and multilateral regime governed primarily by the New York Convention, as well as the ICSID Convention in the case of investor state awards, but one that really plays out in national courts. And so necessarily is affected by developments in the laws and decisions of particular jurisdictions for enforcement. One area that is of perennial interest in enforcement is, at least in the case of awards against states and state-owned entities, is sovereign immunity. So what are some of the key issues currently being raised on this front? And Andrea, I'll toss it to you for this one.
Andrea, you're in mute.
First, I'd like to thank Julianne and the ILW organizers for having me on this panel. It's really a great pleasure to be with you all this afternoon. I'm going to talk about 3 recent ICSID convention case enforcement proceedings involving 2 different ICSID awards. So one award was against Spain and the other against Romania. The enforcement proceedings were in the United Kingdom, the United States, and in Australia. And in all of those cases, various defenses to enforcement arose, including sovereign immunity. So the underlying ICSID cases were McGill versus Romania, that was in the United Kingdom and the United States. And for aficionados, that's happened in other courts as well, but those are the two I'm going to discuss. And then ICER versus Spain in Australia. In both of those cases, in McGill and ICER, the respondent states supported by the European Commission were essentially arguing that intra-EU investor state disputes are incompatible with the European Union legal order. And that argument was made essentially to try to resist enforcement in the municipal courts. Now, most people at this session probably know already that ICSID awards are not subject to set aside in domestic courts. They are subject only to annulment by an ad hoc committee convened under the ICSID Convention. ICSID Convention awards are supposed to be enforceable in the domestic courts of states party to the ICSID Convention as if they were final judgments of the domestic courts of those states. The actual procedural mechanisms for that enforcement are left to the individual states in order to permit ready adaptation to local procedural rules. So in each of these three instances, really the issue was kind of whether and how the insertion of these awards into the domestic legal order might leave open the opportunity to resist their enforcement. I know Julianne mentioned sovereign immunity, but I'm actually in the UK case, it's not really about sovereign immunity. But in the UK court, the question was the extent to which the requirement that awards be treated as if they were local court judgments meant that the intra-EU argument could stop enforcement. At the time of the UK court decision, the Supreme Court of the UK, the General Court of the European Union had annulled the European Commission's decision that payment by Romania of the ICSID award would in itself constitute forbidden state aid. But that GCEU judgment was on appeal to the Court of Justice of the European Union. So Romania sought a stay of enforcement in the United Kingdom on the grounds that if the case were a domestic judgment, the UK courts would need to stay enforcement pending the outcome of the appeal to the CJEU. So, you know, if the ICSID judgment were the same as a final judgment of a UK court, the argument went then that judgment should also be stayed. The United Kingdom Supreme Court rejected that argument on the grounds that staying enforcement would be incompatible with the ICSID Convention. The UK Supreme Court essentially concluded that Romania was effectively seeking to stay enforcement based on substantive grounds rather than on procedural grounds, and that there was in a sense, the international obligation under the ICSID Convention took precedence over whatever the CJEU was going to say. Now, the US case also involved McGill, but that involved sovereign immunity. So US sovereign immunity law contains an arbitration exception. If a state agrees to arbitrate, then it agrees to waive immunity for court proceedings related to that arbitration. And in this instance, I'm talking about jurisdictional immunity, not about execution immunity. So Romania argued that the CJEU's Achmea decision, which said that intra-EU investment arbitration under the Dutch-Slovak Republic BIT was incompatible with the EU legal order, should be extended to all intra-EU investor state arbitrations. Thus, Romania was not able to arbitrate under the Romania-Sweden BIT, so there was no arbitration waiver because there was never any valid agreement to arbitrate. Now, the US District Court for the District of Columbia, in a decision affirmed by the DC Circuit, rejected this line of argument. It first decided, relying on previous judgments, that the Foreign Sovereign Immunities Act's arbitration exception conferred subject matter jurisdiction over petitions to enforce ICSID awards. It actually considered some of the EU arguments, which was kind of interesting. It considered them perhaps more thoroughly than the UK Supreme Court did. But I think in the interest of time, I'll skip that because the basis for the decision was really the arbitration exception, and essentially the decision that by offering to arbitrate, that satisfied the requirements of the arbitration exception. Now, the Australian Federal Court in ICER addressed the immunity question in a slightly different way, but also found that the requirements to exercise jurisdiction under Australia's State Immunities Act were met. The court held that by ratifying the ICSID Convention, essentially Spain had agreed to accept the jurisdiction of related courts, of the courts of other member states to the ICSID Convention. So it relied on the distinction between Articles 54 and 55 of the ICSID Convention. Those many of you know, Article 55, in Article 55, the convention explicitly states that agreeing to arbitrate under the ICSID Convention does not constitute a waiver of execution immunity. The Australian Federal Court said that by accepting enforcement of ICSID Convention awards under Article 54, which contains no explicit reservation of immunity, that Spain had waived any reliance on foreign state immunity from the jurisdiction of such courts in proceedings to recognize and enforce such awards. So these cases show that the interaction between the international and domestic legal orders really does allow various places where arguments to resist enforcement can be made, even though theoretically the ICSID Convention regime was supposed to be self-contained and awards not subject to set aside under municipal law. The ICSID Convention is also different from the New York Convention, given that the ICSID Convention regime explicitly chose not to have defenses to enforcement. So in these three cases, the defenses failed, but the mere fact that they could be raised might be regarded as extra hurdles to enforcement. So I will stop there.
Great, thank you so much. Kabir, do you have anything to add?
Sure. Let me just start off by echoing what Professor Bjorklund said. You know, it is a real honor to be here. This is for international law junkies to highlight this event, right? So I'm very honored, and it's always a delight to be with friends. So I'm thrilled to be here, virtually thrilled to be here, however we understand here. Professor Bjorklund spoke about the consequences of Achmea, right? And that has shaken arbitration, especially as we have seen when it comes to enforcement. I'm going to pivot and pick up another, I think, very significant international law development when it comes to enforcement. And that is, what do you do when a state, capital S state, claims to be represented by two governments, right? There's more than one government that claims to be legitimate. What does an enforcement court do? And is the enforcement court bound by the position taken by the state that that court is placed in? And this is a real problem in international law, right? You look at Libya, Syria, Iraq, and no country, I think, probably drives this point more clearly than Venezuela, right? Where you have the Guaido government recognized by a lot of Western countries, and you have the Maduro government that is, for all practical purposes, the government in force in Venezuela. What does an enforcement court do? Now, I will just note, this matter has gone before ICSID, when it comes to enforcement for ongoing cases. I'm not going to get into that. ICSID tribunals have taken a practical approach. But what does an enforcement court do? In the United States, the district courts of Columbia, at least, right? It starts with the Rosero enforcement action. And I think that the finding is just on this point, who can represent in the enforcement. The very famous line is that the government that may represent a foreign state is a political question, not a judicial question. This is the position that the US has taken. Ergo, since the US government recognizes Guaido, the US courts are going to be bound by that decision. So that's what we're seeing. In the interest of time, I'm just going to skip a lot of very interesting developments and move across the pond to what the UK is doing. And actually, October 5th, so relatively recently, the US Court of Appeal was confronted with an appeal on this very question. Who is going to represent Venezuela? Is it going to be Guaido? Since the UK, like the US, recognizes Guaido, the appeal court there comes out telling, you know what? Even though we recognize Guaido, it is possible that we implicitly recognize Maduro, the Maduro government, as retaining effective control. So they're sort of changing it, the de facto de jure, right? The Latin terms, anything in Latin sounds sexy, right? But they're really saying that even though we may, for practical purposes, recognize Guaido, it may be the Maduro government that has control. So they have sent the matter back to the commercial court to clarify it with the UK. So this remains, I think, a very live issue as to what the UK is going to do and what implications that may have when it comes to enforcement and two governments seek to represent the government. Stay tuned. Hopefully in 2021, when we can meet in person, we can revisit this issue, but I'll stop here in the interest of time.
We'll come to you for an update for sure. I'll stick with you for a moment and pivot to a slightly different topic. Sovereign immunity is something I think we always talk about in the context of enforcement. But in a nod to the theme of International Law Weekend, which is international law in challenging times, obviously every context has been touched by the ongoing COVID-19 pandemic. Are we seeing, or do we expect to see, new issues arising or new versions of old issues coming up in the area of enforcement as a result of COVID-19?
I'm taking a deep breath because that is a big question and we can really spend the rest of today talking about that. But yes, COVID impacts everything, including enforcement of awards. What I'll try to do is I'll try to just perhaps take one real life example so we can see how COVID has actually impacted the enforcement of arbitration awards. I'll perhaps stick to investment arbitration. I do that for two reasons. One being time. We have to hear our other speakers. Point number two is there have been 6,340 conferences on COVID in commercial disputes. I think if I mention the word force majeure and enforceability, people are going to get mad at me. So I'll put a pin there. Look at one of those 6,348 conferences that have spoken about it. But we are seeing in the investment arbitration enforcement context, we are seeing states relying on COVID as a potential defense. And I think we saw that happening in the Teco versus Guatemala case. It's interesting just to see actually what happens in the enforcement. So you get an award in November, the enforcement actions start in DC, right? COVID happens. And Guatemala goes sometime, I think, March, when COVID is really picking up, and says, you know what, Judge, we need some more time in light of COVID to consult with stakeholders and government officials. And in the first instance, when this appeal is brought, this petition is brought before the judge agrees to extend the deadlines in light of COVID. I think a few months later, right, I think it's May, could be a little fuzzy on the time here because COVID days and nights tend to bleed. But Guatemala comes back saying, we need some more time to consult with the stakeholders in light of the pandemic. And I think at this stage, the judge doesn't give a lot of empathy. I think the judge actually fairly candidly says, it looks like you are taking the pandemic and using it as an excuse. And the judge's reasoning, and this is what I think is the takeaway, people are going to start looking at things in a very granular manner, right? When you're talking about the pandemic, what is the pandemic really doing that is impacting your ability to enforce. And the judge here says, you know what, the award came out in November, pandemic, March. What has happened in this intervening time when the pandemic was not enforced, right? So you're really seeing a more granular examination, not in the enforcement context, but, you know, Bolivia had tried to seek an extension, a suspension of a proceeding, you know, a few months ago, again, citing to the pandemic. They revived the force majeure argument in the ISTS context, which is interesting because, you know, necessity has been the, I'm going to use the word sexy defense that has been tried. Force majeure, not so much. And they tried to rely on force majeure. The tribunal didn't rule on force majeure. But again, the tribunal's reasoning was, you know what, pandemic has changed things, but, you know, you can do your filing using technology. So you know, too bad, so sad, let's move on with life, sort of paraphrasing what the tribunal said. That's, I think, what we're going to see. We're going to see a more granular examination on the pandemic, how it impacts the enforcement. What are you seeking in the enforcement? What bucket in international law are you going to place your arguments in? Exciting time to be alive. Pandemic causing a lot of suffering for us as international law junkies. All this is pretty exciting stuff. So let's revisit it in 2021.
Thank you so much. And Lee, anything to add to that topic?
Sure. Thank you, Julianne. And let me just echo the sentiment. It's really a pleasure to take part in this year's International Law Weekend, even if it's virtual. And thank you to Kabir for those very thoughtful comments. So what I'd like to add are some observations on a different aspect of the COVID-19 problem for arbitration. And that is whether changes to the arbitral process that are meant to ensure continuity during the pandemic could themselves be a source of objection to the enforcement of arbitral awards. And for the most part, this has to do with the arbitration process going remote, and especially hearings. The international arbitration community has done an extraordinary job in moving arbitration during the pandemic to online platforms. Virtual hearings are pretty much commonplace now, and by many accounts have been effective. While we're all very pleased with ourselves about how we figured this out, there are still some dangers lurking to be aware of. Now, we all know that the national arbitration laws and the New York Convention provide grounds for objecting to the enforcement of arbitral awards. This includes significant unjustified deviations in procedure that could violate or do violate a party's due process rights. So I think an important question is to think about during the pandemic is whether remote arbitration could precipitate such violations, and in doing so, undermine the enforceability of awards. And one area of potential concern is remote witness examination. This is obviously not new to international arbitration. We've been doing this for a while, but it's never been used as prevalently as it has now. And thus, arguably, the chances of it infringing on a party's fundamental rights has never been greater, especially if remote examination occurs over one party's objection. So some questions to consider might be, is the tribunal really able to assess the credibility of witness testimony through a computer screen? Can you really see the witness sweat that way? How can we ensure that witnesses and experts aren't cheating? They might be receiving texts from their counsel in response to opposing counsel's questions, or they may have secret notes beyond the view of the monitor, or otherwise be coached. How can we properly monitor the sequestration of witnesses from afar? And are the conditions for remote examination fair in all cases? What about the witness or the expert that has to testify? They're 12 hours ahead in a different time zone. It's in the middle of the night for them. Is it fair to subject them to a long cross-examination under those conditions? So fortunately, so far, reports of significant problems are rare, but it's important for parties and their counsel to think and to act proactively. Parties can and should work out an agreed remote arbitration procedure in advance and expressly agree to it. There's a lot of good guidance out there now, a lot of models coming out from the arbitral institutions that can guide you. And look, in some cases, the risks presented by remote arbitration will simply be too great. And tribunals and parties, and particularly claimants, are going to need to use their best judgment and really figure out if it's best to delay the proceedings until the pandemic is over, which is hopefully soon. So I'll stop there.
It's a really great point, and one we're probably at this point sort of only touching the surface of, but sure to be just incredibly important going forward. As you said, not only in the context of structuring arbitrations, but probably for parties to keep in mind, you know, at the point of contracting too, in structuring their arbitration clauses, et cetera. I want to go back to something that Andrea touched on a little bit to start out with, which is that we've mentioned enforcement as a regime that's both international and multilateral, but there's also a regional component that comes into play. For example, in the EU. So how do we see regionalism affecting the enforcement regime? And I'll turn to you for this, Alyssa.
Hi, everybody. I'd also like to thank Julianne for putting this together and ILW for having us. And I did want to pick up a bit off of what Andrea said. I'm afraid this will be a kind of academia heavy discussion. Talk about why I think it's not a one-off and what that means if it's not necessarily a one-off, if it has broader implications, at least for how the CJEU is thinking about arbitration, and the effect that that could have not just on the EU, but on other regions that then might be pushed to deal with EU awards. And finally, turning away from investment arbitration for a minute, I'll just drop a pin in very briefly on the issue of international commercial courts. But to ACMEA first. So why do I think this is not a one-off? Because, you know, post ACMEA, a lot of tribunals have read it down. Most of the awards have been Energy Charter Treaty awards, and all of those tribunals have said, look, it doesn't apply. Right? This is to deal with intra-EU bits. This is this particular situation because of how fast the EU expanded. And now, you know, the countries that were parties to these MITs have basically all signed a thing saying that they're going to get rid of them. There's going to be some litigation still about what that means for ongoing arbitrations, right? But we can cabin that. But if you look at CJU opinion 117, that's the CETA decision, we see some of the same themes coming up. And so CTA, essentially, this was the CJEU reviewing at the request of Belgium, the EU's involvement in the Canada-EU trade agreement, and particularly the investment court that agreement envisions. And in some ways, the court in that agreement is a trial run for the EU's proposals for a multilateral investment court. Right, we're going to have a different type of body now. It's going to be more court-like. We're going to have judges appointed by states. And what I want to focus on in there, though, is what the CJEU said about what would make awards coming from this body acceptable. And it used some kind of confusing language. It said, it would be a threat to the autonomy of EU law if, in the course of making findings on restrictions of the freedom to conduct business challenged within a claim, the tribunal were to call into question the level of protection of a public interest that led to the introduction of such restrictions in the EU. And then they go on also to discuss the importance of the democratic process, right? That the public interest decisions of the EU are the result of a democratic process, and we don't want to let an investment tribunal review that. Right? It is able to make sort of one-off, very specific decisions about what is going on between these parties, but it cannot sort of broaden its remarks to focusing on what were ultimately policy decisions of the EU. Can't criticize, in some ways it can't, we're not quite sure how far it can go. It is not clear, but at some point where there's a public interest judgment coming in, it cannot question whether that was actually a public interest judgment and how that came out. And so that's a very narrow vision of what the tribunal's mandate is. But that's the vision of the tribunal's mandate that the CJU seems to think wouldn't interfere in the EU's relationship with its member states and in the autonomy of EU law. Tribunals have a different view, at least so far. Right, we have not seen post-ACMEI tribunals reevaluating how far they can go in talking about policy judgments that states have made. We have not seen tribunals talking about their power being limited. Instead, if anything, we've seen with the Energy Charter awards, tribunals kind of pushing back a little bit and saying like, hey, no, our mandate comes from international law. We're not part of the EU system. We're not trying to be part of the EU system, but our job is to enforce this treaty and not to worry about what you're doing over there. So in some ways, that's drawing the kind of line that the CJU seems to want, right? They don't want interference in EU law, but it's also saying, we have this separate mandate and you don't control us. So that could be somewhat challenging if that award then gets, if there's an attempt to enforce that award within the EU. And as Andrea already mentioned, right, ICSID convention limits that to some extent. If you're talking about the Energy Charter Treaty and it's an ICSID award, but there are also awards that might come up under the New York Convention where there would be more openness to a public policy challenge. And so then the question becomes whether you then intend to enforce outside the EU and whether you get a sort of separate jurisprudence on what this EU law means outside the EU. I'm thinking particularly maybe in DC, right? We will have a sort of series of cases elaborating whether the CJU's decisions affect the award without input from the CJU or from any court of a member state. And so one question would be what effect that has on jurisprudence over time, right? If you're only attempting to enforce these awards outside of the EU, you're having the conversation about the effect of these decisions. And I imagine that, parties will try to limit them completely outside of the EU, whether the CJU sort of spins off farther towards a regional approach. And I think I've probably taken too much time already, but I did want to drop a pin on the commercial side and this issue of international commercial courts. We've seen the establishment of a number of international commercial courts, some of them with foreign judges, some of them like the Chinese International Commercial Court with local judges, but foreign advisors. And they're kind of new entrants potentially into the market for legal services. And so competing with arbitration, but also when it comes to enforcement, right, reinforcing arbitration.
Andrea, do you want to pick up on this topic?
I'd love to, Julianne. I think that Alyssa is really right. And just to kind of talk a little bit more about the McGill case in the United Kingdom, you have to think that, well, first I should say that I have been an expert in a couple of cases on the side of the claimant in a couple of the European or the Energy Charter Treaty cases and enforcement matters. So I should disclose that. So you can discount what I'm about to say. But I do think the United Kingdom Supreme Court is right on the law in that the ICSID Convention should take precedence over EU law. But that's a much longer discussion than we have time for here. However, it's hard not to think that the UK Supreme Court decision was affected by Brexit. If the United Kingdom were not in this transitional phase, still technically in the European Union for some matters for the transition period, you might think the decision might have been different, if the controlling court in your jurisdiction is going to decide not just a case that has an effect on the case before you, but actually the actual case before you, you have to think that in most cases you're going to stay enforcement pending the outcome of that decision. However confident you are about you're right on the law, and you would probably stay enforcement and then possibly try to work around your controlling court judgment. But anyway, so I think that is, you know, the UK Supreme Court decision is partly due to the fact that the UK is on its way out. So I agree that EU courts might very well take different approaches. And you know, it's not, you know, Alyssa mentioned the kind of the public interest, the concerns about that. You know, we also have the provision in CETA, Article 8.31, that tries to get round the Acmea question by saying that tribunals shall, you know, cannot determine the legality of an EU measure that is alleged to constitute a breach. Under the domestic law of a party, they may only consider the domestic law of a party as a matter of fact. You know, when and where the line between treating domestic law as a matter of fact and applying it is not always altogether clear. So I think that's another avenue where you might see the European Commission, your EU member states and courts, let's say, questioning what an investment tribunal will do. And another thing that might lead into the next topic, but I'll mention it here. And we don't see much discussion about this, but I note that the European Court of Justice, the Court of Justice of the European Union has some role to play in the actual payment of awards. So within the European Union itself, no award can be enforced against the EU as a state party unless the Court of Justice of the European Union approves that award. The property and assets of the Union cannot be the subject of any administrative or legal measure of constraint without the authorization of the Court of Justice. So there are kind of several avenues for, I don't know, appearing in a sense before the EU courts. And I'll stop there.
That is indeed a fine segue to our next segment. Alyssa very bravely pulled us out of the investor state context for a moment, but I'm going to drag us right back in. So obviously we hear, in the context of ISDS, we hear a lot about ISDS reform proposals right now, whether that's an investment court, other proposals being discussed at Working Group 3, et cetera. But we hear, I think, relatively little about how those proposals could affect the current regime for enforcement. So what are the questions we should be asking, and how could or should current proposals take enforcement into account? And I'm gonna unsurprisingly turn to you, Lee, for this question.
Sure, thanks, Julianne. Happy to take the question. And there's a lot, as you say, going on in the area of ISDS reform proposals. So I'll talk a little bit about proposals that are being put forth in the context of the work of Working Group 3 of UNCITRAL. And there are two proposed reforms that, if adopted, would really substantially change the structure of the current ISDS system and would raise really interesting questions about how, under a new system, enforcement would work or maybe wouldn't work so well. These are the questions. So the first proposal involves replacing the current ISDS system with a permanent investment court. And that would include a standing body of judges of first instance level and appellate level. And the second proposal involves the addition of an appellate mechanism to the current ISDS system. So they would exist roughly in parallel. Now, with respect to a permanent investment court, states would be replacing the current ISDS system outright, or almost outright. And because of that, they would likely not have the benefit of the ICSID Convention, and particularly Article 54 of the Convention that requires all 155 or so contracting states to enforce an ICSID award made, as it says, pursuant to the Convention, as if it were a final judgment of a court in that state. It's likely too much of a stretch, I think, to say that judgments of a permanent investment court would be made pursuant to the ICSID Convention, when the ICSID Convention contemplates a much different dispute resolution process. So to establish a permanent investment court would require states to consider two things, at least two things. First, they need to figure out how court judgments, investment court judgments, can be enforced inside the territories of the court's contracting states. And second, preferably, how such judgments can be enforced in the territories of third states, that is, the non-contracting states. And the latter may be quite important because certain states, like the United States, likely won't be joining a permanent investment court, at least anytime soon. On enforcement within the territories of a court's contracting states, the treaty establishing the court could simply include an obligation like the one in Article 54 of the ICSID Convention that says the parties, the contracting states, are obligated to enforce any permanent court investment court judgment as if it were a final judgment of a court in that contracting state. So, okay, problem solved, but only within the territories of a court's contracting states, which may be limited, especially in the beginning of a permanent court's existence. So to ensure enforcement in third states, and again, without the benefit of the ICSID Convention, we'd have to see if the New York Convention could apply. And this prompts a number of questions, and I'll just touch on two of them here in the interest of time. First, would judgments of a permanent investment court meet the definition of arbitral awards under the New York Convention? That definition includes awards made by arbitrators appointed for each case, as it says, and also those made by permanent arbitral bodies to which the parties have submitted. Some say the New York Convention would apply to permanent investment court judgments because, like ISDS, the parties would be submitting to the process voluntarily. It's like arbitration. And there is some precedent in US jurisprudence for treating at least the semi-permanent Iran-US Claims Tribunal as a permanent arbitral body under the New York Convention. But it really remains to be seen if national courts will treat a permanent investment court, which could be qualitatively very different in the same way. Another important question is whether the disputing parties before a permanent investment court can validly waive the grounds for refusing to enforce awards under national arbitration laws or Article 5 of the New York Convention. If not, then a permanent investment court judgment would be subject to a second level of review, potentially, before a national reviewing court, even if the judgment had already been appealed at the permanent investment court. And while this issue has not squarely been addressed in US courts, the approaches of the Second, the Fifth, and the Ninth Circuits in rejecting waivers of set-aside grounds strongly suggest that they may also refuse to accept waivers of grounds to object to enforcement. And let me move now very briefly to the topic of a freestanding appellate mechanism. This is the second possible reform proposal being discussed. This raises equally interesting questions about enforcement. Here, the main issue is more about if we bolt an appellate mechanism onto the current ISDS system, can we still use the New York Convention and the ICSID Convention to enforce ISDS awards? And in the interest of time, I'll jump to the ICSID Convention, which is probably a little more interesting. And here, if applicable, Article 54 of the Convention would avoid the problem of national court review and would allow enforcement in all 155 ICSID Convention states. But, and this is a pretty big but, the ICSID Convention establishes a self-contained system of arbitration, and Article 53 says that ICSID awards, quote, shall not be subject to any appeal or to any other remedy except those provided for in this convention. And we know that those provided for in the convention are interpretation, revision, and annulment only. So if the ICSID Convention is going to be used to enforce ICSID awards that are subjected to review by an appellate mechanism, the convention will likely either have to be amended by all ICSID contracting states or modified inter se, that is through some sort of side agreement between willing parties. The former solution seems very unlikely in terms of the present political positions of ICSID states. And there's been a very interesting debate among commentators about whether the latter solution, inter se modification, could actually be achieved in practice. Some say under treaty law, the prohibition in Article 53 against appeals makes it impossible. and there's equally respectable people on the other side saying it's perfectly possible. So those are the interesting issues that are coming in the work of the working group, and I'll turn it back to Julianne.
Great, thank you. It's really interesting. Alyssa, do you have anything to weigh in on for that?
I think Lee's given us a pretty big good rundown of the enforcement issues. I will just say it's been interesting to see the alignments between different states and regions here. We're seeing kind of a group of players coalesce around a more hierarchical arrangement. So if we think back to sort of, I'm going to bring in Mirai Damashka's divisions between hierarchical and coordinate authority, be an academic for a minute, but the arrangements so far have really relied on coordinate authority and the idea that we don't necessarily want something sort of forcing multiple tribunals to come out the same way. But there's now this demand for more hierarchical authority, for a right answer and for an appellate mechanism. And it's been interesting to see that even states that haven't necessarily endorsed the idea of an investment court have endorsed the appellate mechanism. So you could see a real shift there in how they approach investment law and what it's supposed to be. Right.
Kabir, I sense that you would like to weigh in on this as well.
Sure. I mean, I think we've had such excellent interventions by both the professors. So let me just, sort of pick up and tease out some of the points that I think are very interesting from where I'm standing and looking at it. It seems to me consensus in investment arbitration is very hard. No two people seem to agree on anything. We're going to see that move into the enforcement realm. And so whatever we are going to get is going to be something fairly watered down. And I just want to point out here that for me personally, we tend to think of countries having positions and well thought out positions. But the reality of the day is that countries seem to be very inconsistent in what they're doing. If you look at the US, everything is a mess for a variety of reasons. Yeah, I'm trying not to be political, hard to do so. But when we're looking at least at Working Group 3, the US is surprisingly not one of the most passionate advocates, as the US has typically been, for retaining the system. Countries like Chile and Japan are taking a much more passionate role there. I'm going to pick up on the example of Canada to drive home how countries just don't do things in a very consistent manner. I do this for two reasons. We have two fabulous professors from Canada with ties to the US, but we have two Canadian professors there. And I think right now Canada does stand out as probably, a best example for rule of law. Canadians tend to disagree, but I think from our vantage point, we will probably trade positions in a heartbeat. But you look at CETA, where Canada is a state party, and the vision for dispute resolution is this court mechanism. You then move on to the CPTPP, right? The Trans-Pacific Partnership, where Canada is a party. It was the TPP US pulled out on day one, right? And then it became both comprehensive and progressive. But here in that treaty, we're seeing, again, with Canada, we're seeing ISDS largely modeled on the US 2012 model BIT. So you see a different model in another very major treaty. And then we look at I love to call it the USMCA, the USMCA. Again, Canada a party here, and Canada here taking, the no ISDS in any form approach. Now, wink, wink, smile, smile, because Mexico and Canada are both parties to CPTPP. So somehow there is ISDS available there. I just point this out. It's going to be interesting to see what we're going to get and what form it has. I'll stop here.
Great, thank you so much. I have one final question for all of our panelists. I see that we're getting a couple of questions already from the audience, so please do send any questions you have, and I'll ask you all to just be very brief on your last intervention so that we can get to a couple of the questions from the audience. But so enforcement gives us an example, and we've had a number of them today of multilateralism that has been very successful. We've talked about several places today where the tension between harmonization and national implementation comes into play. So looking forward, how do we correct those variations that we've talked about? But maybe more importantly, do they need to be corrected? Is this, an aspect of the system that, is either inevitable or is actually beneficial in some ways? So again, if you could just keep your responses relatively short so that we can get to questions, that would be great. And I'm just going to go counterclockwise from my own face. So Lee, you're first.
Sure, I'll be very brief, and just to follow up on my last intervention. Yeah, I mean, I think if we do move to some of these structural changes that are being proposed, as I mentioned, it's going to raise questions about how enforceable awards or judgments or whatever they may be are. And you'll probably look for things. There's already some commentary suggesting that there would need to be an interpretation of the New York Convention to ensure that its national courts and interpret it in a way that would make judgments of an international court, investment court, be enforceable. So I do think we'll see some things on the margins there.
Alyssa?
Yeah, I agree. This is going to be an area where there's going to be a lot more of a push for and a felt need for harmonization, and also that a lot of the players on the investor state side, as well as on the commercial side, right, are usually pushing for some sort of a harmonization and regime, and I think that will continue. But procedural harmonization doesn't mean underlying agreement on procedure values. And that may be where, for example, with the investment court, we're now going to have the fight because those start to come up.
Kabir?
Sure. We have a framework available through the New York Convention. I think to the extent we want to find consensus, we should do it through soft law. That's how you should do it. What Professor Bjorklund did with the restatement, something like that, we do more globally. But I don't think it should be something in the form of hard law. That's probably not a good idea for a variety of reasons.
Andrea, over to you.
Well, first I have to say, I mean, the restatement was really not my work. I was a very tiny, tiny cog, so I cannot take credit for that. Thank you, Dr. Duggal. But, I'm interested, you're framing this with respect to the New York Convention reminds me of what Kabir said, which is, how hard it is for people to agree on anything. And you can look at that just in the context of the New York Convention, where you have a very strong line of argument that it needs to be updated, modernized, and changed, and in equally, equally respectable, powerful voices saying, this has worked really well for 50 years. Like, why would we mess with this? Like, we need, and there I think, it's useful to have that national latitude, right? It might not be perfect for predictability, but it's useful to have that national latitude because it is hard to get people to agree. And I think what we're seeing in Working Group 3 is maybe, I mean, I don't want to quite say a sleight of hand, but maybe, a little bit of a sleight of hand in that we're focusing on procedure. We can query a few instances, what's procedure and what's substantive, but, focusing on procedure with the illusion that lawyers often have, that if we can just get the procedure right, everything else will follow perfectly. But it's hard even to get the agreement on the procedure, and they're ignoring entirely differences in substance. So we can, can we really have an appellate body achieving harmonization if we have really different treaties? I mean, maybe we can have harmonization within the same schools of thought in those treaties, but will either the appellate body or the public that is clamoring for predictability, consistency, be interested in hearing arguments about how the United States and Canada have the minimum standard of treatment, that it has fair and equitable treatment as a subsidiary standard, but other states have chosen to have a free-floating fair and equitable treatment standard. Will the tribunal try to harmonize that? And will the US and Canada be at all happy if it is harmonized in a free-floating fair and equitable treatment way? And I'm thinking the answer is no, but I mean, taking the point that we don't think the US is going to be a part of this, but nonetheless, I still think they would probably not be happy. So I think there are going to be a lot, there are a lot of big hurdles ahead. And so maybe soft law, or maybe less ambitious goals, or leaving some room for play around the joints is going to be essential to achieve some kind of agreement on something.
Thank you so much. So we have one question from the audience, which I will pose, and I will also put the CLE code back on the screen for anyone who joined late, and make sure you take it down because you're going to need to submit it in order to get CLE credit. So the question from the audience is, what would be the effect of ICSID UNCITRAL draft code of conduct on the enforcement of awards? And I'll take volunteers. And if there are none, I'm gonna cold call you, I guess. The professors will, there we go.
I'll volunteer. I was on a panel about the code of conduct a couple of weeks ago. So I think that's an interesting question. I think you could add it, you could answer it like very directly, what effect would there be on enforcement? And you could say, there are not very many awards that are not enforceable because of actual violations of codes of conduct. Although one, ICER versus Spain, which we've just been talking about, is certainly one of them. So presumably it would have a beneficial, if standards for independence and impartiality were more clear, query whether they have to be that much more clear, but if they were more clear, perhaps that would be beneficial for enforcement. I think a different question, but related question, is whether it would be beneficial for acceptance and voluntary payment by states without having to go through a formal enforcement process. In other words, if there were a code of conduct that alleviated some of the concerns that states have expressed about independence and impartiality, and if all of the decision makers adhered to that code, would there be more acceptance of the award and less likelihood of challenging the award? Maybe on other grounds besides independence and impartiality, but just more acceptance of the system. And that's at least a possibility, and I'm sure that it is a hope of those who are advocating the code of conduct.
Great, thank you. We have 1 minute remaining, and we have one question from a student, a 1L interested in this field, which is not enforcement specific necessarily, but I think will be helpful to many of our members, which is recommendations to learn more about the principles of international arbitration, current events and conflicts in the field, books, podcasts, journals, etc. I would say coming to ILW is a great start. Any other suggestions from our group?
I can chime in. If your law school offers it, take the class. General principles. Are there general principles? You will learn that isn't a huge fight. You will get to, and if you take the class, you will probably learn all about it. But one of the things that I think is so fun is that so many different things come into it, right? So yes, take the class in arbitration if that is available, but also your classes in international law, your classes in comparative law. And a class that gets you to think comparatively, even if it's not about arbitration, can be a model for the type of thinking that you end up doing a lot in this field. I'm sure we can all suggest sort of favorite blogs if you want to read the news. Kluwer and Egil come immediately to mind. But
And
great,
I
I'm glad you're
believe
interested.
Kabir has suggested some other blogs with some great titles in the chat function. So please take a look at that. I think that brings us to the close of our time here. Just a huge thank you to all of our panelists. I see some more answers coming into the chat, so make sure you look at that. Huge thank you to all the panelists. Thank you to Abila's International Arbitration Committee, which sponsored this panel. Thanks so much, and everyone stay healthy and stay safe.
Many thanks to you, Julianne.
Thank you. Thank you all.
Thanks, everybody. Bye.
I thank you.
Nice to see you all.